the union can go to the board and say this isn't good faith bargaining.
Mm.
But then the remedy, if the board agrees that the employer is engaged in bad faith bargaining, is to tell the employer to go back and have the right frame of mind. So the PRO Act would change that by saying after a union's elected for the first time, there's a 90-day period of bargaining. That looks, kind of like bargaining looks now. And then there's a 30-day period of mediation, and then there's first contract arbitration.
Well, thanks so much for coming on the show. It's so great to see you.
Yeah, it's great to see you too.
I have so many things to ask you. I feel like I've been building up like a list of questions. Like, I wish I had Charlotte's take on that. Like, I wonder what Charlotte thinks about this. I guess maybe we should start with the PRO Act. When was the last time there was like a major piece of legislation that passed that actually like reformed labor law?
It depends a little bit by what you mean by major, but I would say probably the 1947 LMRA, the Taft-Hartley Act, and that was a major change. It created a set of union unfair labor practices, right? That was a reaction to the idea that unions were just too powerful, right? Like it's hard to imagine that today.
Why hasn't there been like more legislation in this area?
There have been proposals for, sort of varied aspects of labor law reform. I would say they haven't been as ambitious as the PRO Act is.
Okay.
As you might remember from the Employee Free Choice Act, which was debated at the beginning of President Obama's presidency, it's just hard to get to, or what at the time was 60 votes in the Senate to overcome the filibuster.
Here's my very rudimentary understanding of the PRO Act, which is like there's this really major piece of legislation. No, and I only have kind of fuzzy sense of what it would change. So I'm hoping you could like educate me on those matters.
So the PRO Act, your understanding, first of all, is totally right. It is a piece of legislation. It's passed the House. It's awaiting action in the Senate. It would fix a set of problems that relate to restrictions on how workers and unions can engage in collective action, putting themselves at kind of unreasonable risk of like financial destitution. And it would fix problems with the bargaining process that allow employers, especially when a union has just been elected for the first time, to just sort of wage a campaign of attrition, sort of refuse to reach a contract, and eventually, hope to erode support for the union as time goes by.
You said remove the risk of financial destitution?
The National Labor Relations Act makes it an unfair labor practice, right? Makes it illegal for employers to fire workers because they strike.
Okay.
However, in a substantial number of cases, employers can instead do something called permanently replacing workers.
It sounds the same.
It does sound the same. There are some like technical differences between those two statuses, but if you've been permanently replaced, even when the strike ends, you can't go back to your job.
Wow.
Labor law doesn't protect ways of striking that reduce the risk of permanent replacement. So right now, labor law doesn't protect something called intermittent striking, which is kind of what it sounds like. Workers, strike for a short period of time and then go back to work. So if you engage in intermittent strikes, right, it makes it hard for employers to actually permanently replace them.
Okay, so intermittent strikes aren't allowed?
I mean, it's not that they're not allowed, but they're not protected.
Okay, so how would the PRO Act fix that problem?
So the PRO Act just has language that says that strikes don't lose protection because of their duration or intermittency.
Okay, what happens when a union just gets elected? What's the problem now that you're seeing?
Yeah, so when a union first gets elected, that triggers an obligation for the employer to engage in good faith bargaining.
Okay.
And that sounds great, except that good faith is just like a state of mind. And so if an employer, sits down with the union, but then refuses to actually come to an agreement, you the union can go to the board and say this isn't good faith bargaining.
Mm.
But then the remedy, if the board agrees that the employer is engaged in bad faith bargaining, is to tell the employer to go back and have the right frame of mind. So the PRO Act would change that by saying after a union's elected for the first time, there's a 90-day period of bargaining, and then there's a 30-day period of mediation, and then there's first contract arbitration.
Okay. So like a dispute resolution kind of setup.
Exactly, yeah. So like a panel of 3 arbitrators would get together and they would consider things related to the, employer's financial situation, to the worker's financial situation, and would say, okay, here's a fair first contract that will apply for a period of 2 years.
It just seems like the threat that an arbitrator might decide maybe forces the employer to actually bargain.
Yeah, absolutely.
I thought it was interesting that there was like a little provision in there to end forced arbitration for, without regard to the unionized workers or not, just outside for all workers, fixing the forced arbitration problem I saw was like in there in a little section.
The PRO Act would solve that problem for employees by saying that one form of protected concerted activity is filing a mass or a class action or a collective action, either in court or potentially in arbitration.